Hear ye, hear ye, hear ye. The Court of Appeal for the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Good afternoon, everybody, and welcome to today's session of the 14th Court of Appeals. We have one argument on the docket today, which is number 14-19-1020-CV, K. Griff Investigations, Inc., and others versus Cronin, Reardon, and Whitman Security Consultants, LLC, and others. The order of business today will be, we will hear first from counsel for appellant, Mr. Hootman. And do you wish to reserve time for rebuttal?
Yes, 7 minutes.
Okay. And then I understand we'll hear from Mr. Knight first from the appellees?
Yes, Judge.
Okay, and how much time are you going to be speaking?
Jeremy, did we decide upon 10 and 5?
I think so.
Okay.
Okay.
10 minutes for me, and then the remaining 5 will go to Mr. Stone.
All right. And I know all of you are familiar with the procedure here, but I want to make sure everyone can see the clock on their screen. Mr. Hootman, can you see the clock?
Yes.
Mr. Knight?
I do not.
You don't see the timer?
Oh, I'm sorry. Yes, I see it. It's reading 8 right now. Yeah.
Right. And Mr. Stone?
I see it.
Okay. All right. Very good. Then we are ready to hear from Mr. Hootman.
Okay. The way that I approach this case, trying to put it all together because there's a lot of moving parts here and we have a short amount of time here. I think that the case initially or ultimately gets resolved once the write-up problem of figuring out how to write this thing up. I think it's one of the few civil cases that turns on inferences and how inferences work. And of course, in summary judgment proceeding, you're supposed to view the inferences in the favor of my side. And so like in a criminal case, you typically have inferences because people that commit intentional acts typically don't go out and do overt things. So you have to take some facts that you know of, and then you infer that the criminal intent was there based on what you have. So here you actually, and most civil cases don't seem to turn on inferences. They turn on actual facts that were seen or testified about. And so here you have this long line of all these different actual facts that we have, and then you have all the inferences that that CRW was complaining greatly about in their brief about my brief, and they're saying that a lot of things that I said in my brief were not facts, but they're inferences that are reasonably drawn from the facts that are all throughout the record. And so, for example, the emails and the timeline that are clearly established by the citable evidence in the record, which I compiled into one document. I think it was Appendix 2 to my brief. When you take all of that, you draw the inferences that I was talking about in my brief, and that Mr. Knight was so vigorously complaining about. And and it was interesting that his complaints about my brief first kind of made me angry, but then when I thought about it, I could see why he was trying to do that, because he doesn't want those inferences to come in. And so when you're analyzing this case, you first have to figure out what are the reasonable inferences from the evidence, which is a lot of work in this case because there's so much testimony and all these motions and stuff that occurred. But they are laid out there by the affidavits, which are consistent with the emails and text messages. And so if you're going to view the inferences in the light most favorable to my side, then you come up with all these very powerful inferences that end up showing that there were fact questions on all of these theories of recovery that were thrown out. Now, for example, if you look at the negligent misrepresentation compared to fraud, that goes to intent. If you intentionally misrepresent to somebody, then it's fraud. If you just mistakenly misrepresent, then it's negligent misrepresentation. So that's where the inferences come in. And so the trial court, if the trial court has concluded that there's negligent misrepresentation, some facts to support that, Just by operation of logical inferences, well, it's possible that it's also intentional, meaning that there would be fraud. And so once you go through that analysis of inferences, then, for example, on the fraud theory that was thrown out at summary judgment, then you obviously have to reverse because there's some evidence to support that theory also.
Let me
Again,
interrupt you, Mr. Hoopman, real quick. What are the statements, the statement or statements that you're contending there's a fact issue on the fraud claim? What were the fraudulent statements?
I'm sorry, I didn't understand your question.
So what were the fraudulent statements?
Oh, there are a whole series of basically they were saying that they had money, and then also most of the statements came through the people at CRW, and then they were basically saying that they had money, that they were ready to do the deal, but then it turns out you got this guy in the back that's actually got the money. And he's telling everybody what to do and how to do it, and et cetera. And so those are all the false statements and failure to disclose relevant information. So they're just
what's the information that was not disclosed?
The ability to find, and they said at the very beginning that the money was not a problem. And it turns out that they didn't even have the money, and they were not telling the whole story to my client because they couldn't allow, they didn't, Bill did not want to have his name out. So Bill was telling everybody what to do from behind the scenes, and they were telling my client that they were going to do the deal, that all the elements of the agreement had already occurred, and that's why they extended the deadline out to close, because the closing was supposed to occur on a certain date, and then they extended it not because those four elements of the agreement hadn't occurred, but because Bill had not agreed to give them the money, but they had already said that they had the money, and so my client was incurring these additional expenses and doing all this costly stuff to get the deal to close when they were saying that it was already a go. And that's just some of the, many fraudulent things that were being said.
Are you saying a representation was made by CRW that they had in fact secured financing?
Oh yeah, definitely. They said they have the money, and money's not a problem, and it's a go. Because that was also one of the, they said that at the beginning. And then they also said it at the end when they were saying we're ready to do the closing. But also the facts in this case are highly detailed. So you got to. That's why I have them all itemized in the appendix too. Because if you go read those actual emails and text messages chronologically as this thing panned out, then you can start seeing what really happened here, which is they were saying that they could close, but they couldn't. And then it turns out that Bill did not want to do the closing because he had some problems with his people at CRW. And then also Bill was setting up to do the closing, and he was only going to do that if he had 50% control of the company. So he forced out several of the so-called passive investors. And he said that either y'all sell me your interest or I'm going to quit funding CRW. Because CRW couldn't even operate without Bill's money. And none of this was disclosed to Kathy, Kathy Kathy and her company. So anyway, all of that comes back to the inference problem that I was talking about. And then once you get past the facts, if you think the facts viewed in the light most favorable to the plaintiff, like I say, then you just go through then you encounter these multiple legal problems, that some of them are quite interesting. And then you can start dealing with those one at a time. But it all does hook back to these initial inferences that I'm talking about. So I see my time's closed.
Okay, thank you, Mr. Hoopman. We'll hear from you on rebuttal.
All right.
Are you ready for me?
Yes, sir. Let's make sure we can see you. Hang on. We're moving people in and out of the room. So hang on one second.
I've got a message. The host has asked you to start your video. Do I say start video?
Yeah.
Okay.
Yeah, there you go. We can see you.
Okay. May I proceed?
Yes.
May it please the court, Steve Knight on behalf of Kyle Financial Group, Bill Taylor, and his daughter, Brandy Taylor. About a year and a half before the jury trial, and almost 2 years after the lawsuit was filed, the court granted the Kyle defendants no evidence motion for summary judgment in part, dismissing Kathy and Kagriff's claims for negligence, fraud, and tortious interference of contract. On appeal, Kagriff challenges the dismissal of their fraud and negligence claims only. They do not assign error to the dismissal of the tortious interference claim or to any aspect of the trial itself, which resulted in a final take-nothing judgment against them. The court should affirm the summary judgment ruling because Kathy and Kagriff failed to come forward with more than a scintilla of evidence on the challenged causes of action. The court should modify the judgment in part, reversing the narrow findings that were made against Bill Taylor during the jury trial and remanding the case for further proceedings with respect to our request for taxable costs of court and for sanctions. As the court knows, the record in this case is extremely long and dense. But as we have summarized the facts on pages 1 through 15 of the brief, the background of this case is actually very straightforward. Kathy Griffin wanted to sell Kagriff's assets. A company called CRW was interested in buying those assets. From March of 2015 through June of 2015, CRW and Kagriff entertained several meetings where they discussed the possible sale of the assets. By early July of 2015, CRW and Kagriff signed a letter of intent agreement that specified very clearly that each party was to bear their own costs and expenses throughout this process, and moreover specified that any closing on this potential sale is conditioned on the occurrence of several key events. One of which, most importantly for this appeal, is CRW successfully obtaining financing for the hefty purchase price that Kathy commanded, which was going to be $750,000, assuming CRW could get financing. CRW turned to Kyle Financial Group, which is a small lending company owned by Bill Taylor and then his wife, Linda Taylor, and their daughter, Brandy, is its vice president. CRW had previously extended a substantial loan to Kyle Financial Group had previously extended a substantial loan to CRW back in 2014, and CRW was substantially indebted to Kyle Financial Group, not repaying any aspect of the loan, and in fact, they were in default under the prior loan. Kyle Financial Group, as a prudent lender, did what a prudent lender would do. When CRW asked for additional financing, Kyle Financial performed its own due diligence to see if it wanted to extend another loan to CRW. As detailed in our brief on pages 6 through 11, the due diligence process that Kyle Financial performed with CRW revealed that CRW was not responsive. They were not cooperative. They had no coherent business plan for how they were going to repay the $750,000 as well as the prior loans. They had questionable accounting entries and expenses, and worse, various emails that were exchanged suggested that they were shielding financial information from Kyle Financial. Kyle Financial, as a prudent lender, did what a prudent lender would do. They decided that they were not going to embark on another investment that they were not going to get repaid on. So they declined CRW's loan request. The letter of intent's conditions of closing never occurred, so there wasn't a sale with CRW and Kagriff. Instead, Kathy sold her business's assets to another company called KGI Holdings LLC, commanding a greater purchase price in exchange for the sale of all assets, including its intangible assets, meaning its claims and legal claims and causes of action. Despite this, Kathy and Kagriff filed this lawsuit in February of 2016 against literally everybody that they encountered throughout the negotiations with CRW. And they included as defendants Kyle Financial Group, Bill, and Brandy. In December of 2017, the court, as I noted, dismissed the negligence, fraud, and tortious interference claims. And the remaining claims, which were detrimental reliance, promissory estoppel, negligent misrepresentation, conspiracy, were all tried to the jury in June of 2019. A 27-page jury charge resulted in a final take-nothing judgment against Kathy and Kay Griff. They didn't file a motion for new trial and don't complain about the trial. Instead, they want to go back to the 2017 summary judgment order. The trial court properly dismissed their negligence claim. In the Kyle defendants' no evidence motion for summary judgment, they challenged every element. They argued that there's no evidence that the Kyle defendant, as a lender, owed this potential seller, Kay Griff, a complete stranger to the Kyle defendants, any sort of legal duty, no evidence that they breached a duty, and no evidence that any alleged breach would ever proximately cause damages. In their very short summary judgment response, which led with a request for a continuance, their argument really boiled down to this. Because Bill Taylor was a passive investor in CRW, then CRW, and because CRW signed the letter of intent, then the passive investor, and apparently anybody that has had any relationship with the passive investor, including his finance company, including his daughter, must all be liable to this complaining party. The problem with this theory is that it's contrary to the law. Members of an LLC are not personally liable for the company's debts under Texas law. The letter of intent, moreover, contemplated that CRW hadn't had financing yet. That's why it conditioned the closing on them securing financing. CRW applied for the loan and it was denied. That is no evidence of any sort of duty owed by a lender to a seller out there that they have no business dealings with. With respect to the breach element, Kay Griff's argument back was, quote, the defendants did not negotiate the parties' transaction in good faith. Well, if you look at the affidavit that they attached to their summary judgment response signed by Kathy Griffin, and this is at CR 496, paragraph 5, Kathy Griffin in her affidavit attributes 100% of these negotiations to the CRW folks, not Bill Taylor, not Brandy, not the Kyle financial defendants. They were completely uninvolved in these negotiations. They failed to come forward with any evidence on the breach element. With respect to damages, once again, they relied 100% on an affidavit signed by Kathy Griffin. The problem with this theory is that Kathy Griffin assigned 100% of the damages to the alleged misrepresentations that she assigns to the CRW people, which are separate from the Kyle defendants. The court properly granted the summary judgment on the negligence claim. And if you'll note on the appeal, they don't even mention this summary judgment order until page 69 of their brief. And they don't address the summary judgment ruling in any other than on page 69 and 70, but they purport to incorporate other arguments set up somewhere else in their brief. But those arguments were primarily aimed at CRW's separate traditional motion for summary judgment that raised arguments and issues that the Kyle defendants didn't raise in their no evidence motion. So nothing that they say on appeal changes this result. With respect to the fraud claim, the Kyle defendants challenged on no evidence grounds each and every element of the fraud claim. In their summary judgment response, Kathy Griffin addressed the fraud claims in a single page on Clerk's Record 489, a single page dedicated to this claim. And that's where they argue, quote, in executing the letter of intent through CRW, the defendants falsely represented things. Well, there is no evidence, and I'm not even sure what that means, but there's no evidence that the Kyle defendants executed a letter of intent through CRW. The Kyle defendants, they are a bank. They're a lending company. They were asked to extend a loan and they didn't do so. They had no involvement with purchasing Kay Griff's assets. The lending institution is not an investigation company. It's a lender. So this notion that they just put words together to say that the Kyle defendants were somehow involved with negotiating the letter of intent, but their words are not evidence. And there's no evidence in the summary judgment record to support these claims. On appeal, in their brief on appeal, on page 69 to 70, they give scant attention to this issue. They incorporate other arguments earlier in their brief suggesting that there was an ongoing series of actions and misrepresentations, et cetera. But the fundamental problem that KGRF has here is all of these emails and text messages and things that we heard about earlier today that Mr. Hootman suggests gives rise to some sort of an inference of some sort of a fact issue. I'm not sure what it is. But the problem is all of those emails that he summarized and attached to his brief as an appendix, they were not attached to the summary judgment response. None of that stuff was summary judgment exhibits. Kathy Griffin attached various affidavits from her company employees talking about the efforts and things that they did gearing up for the sale that they hoped would happen. But the emails that he's summarizing weren't submitted as part of the summary judgment record. And none of those emails, regardless, portray the Kyle defendants as anything other than what they were.
Mr. Knight, if I could interrupt you briefly, I think I understand your position on your as an appellee, but I had a question about your cross points. Your cross point with regard to the finding against Mr. Taylor. So you have a take nothing judgment in Mr. Taylor's favor. Our rules say that an error is reversible if it causes an improper judgment. And since you've got a take nothing judgment already, even if we were to agree with you that the findings against Mr. Taylor were unsupported, how does that error cause an improper judgment? Or how did that error cause an improper judgment?
Well, I think, first of all, the judgment is an improper judgment because it recites findings that the jury improperly made against Mr. Taylor. And I would like those findings that are in this judgment of public record stricken from the record because they're not justified or supported by the evidence. And moreover, to the extent my opposition is relying on those findings as it relates to who's entitled to the taxable costs of court, then that would be another manner in which it affects the judgment. Because my position is that that aspect of the judgment needs to be reversed and the case needs to be remanded for the taxable costs and also on our request for sanctions because the court erroneously didn't let us submit evidence in support of that and also denied us even a basic evidentiary hearing on that issue.
All right. If you have a case that grants the relief you're asking for, I would like to see it. So please, if you have one, supplement it, and I'd be interested in seeing the authority.
Yes, Judge, will do. And with that, I think I need to turn my the remaining time over to Mr. Stone.
Okay.
May I proceed, Your Honor?
You bet. If you need a minute or two extra, that's fine.
Okay, thank you. May it please the court, my name is Jeremy Stone. It's my pleasure to represent Mark Reardon in this case. Mr. Reardon was a member and the COO of CRW. He was a 31-year veteran of the DPS, retired, started his own investigation company, then started CRW with Mr. Cronin and Mr. Whitman. And then the factual events leading to the negotiations with Ms. Griffin and K. Griff happened as Mr. Knight recited them, so I won't go into that. I'll try not to repeat what he talked about. The trial court correctly granted summary judgment in favor of Mr. Reardon on the plaintiffs, K. Griff's and Kathy Griffin's claims for breach of contract, negligence, and fraud. The only parties to the contract, what I call the LOI, that agreement that was signed in July of 2015, provides conditions for closing. Mr. Knight went over those, but it's undisputed that at least 3, and we contend all 4, never occurred. There was never a completion of due diligence to CRW's complete satisfaction, to its absolute satisfaction. There was never a finalization and execution of a mutually agreeable purchase agreement. There was a draft. It was 17 pages long, which is evidence that, that the parties contemplated more than what was in this LOI. There was never a finalized and executed non-compete and employment agreement with Ms. Griffin. And the most important part here is that CRW never obtained financing. You know, the only thing Mr. Reardon did wrong in this case was that he was excited about the potential opportunity to have this new company, this merger. He worked tirelessly to try to get it, to try to help things along. You know, if you look at the record, there's a ton of emails. There is a lot to this record, but we're looking at just a few weeks of stuff happening in July of 2015. And, you know, to this day, Mr. Hoopman and the appellants still cannot point to a specific representation that Mr. Reardon made that was false, that Ms. Griffin or K. Griff relied on to their detriment, that caused them damages. The only thing he did was, you know, try to do what he could to help the due diligence process along. Another thing I'll mention here is that on the same day, I think that this LOI was signed, Mr. Reardon learned that he had cancer, so he was dealing with that in the same time that all of this stuff's going on. My time's running short. I just wanted to hit real quickly that the Texas Business Organizations Code provides that these LLC members are not liable for any contractual obligation which has been held to be anything related to business related. Really, we've got this LOI. This whole dispute is related to this contract. And even though the sale of assets was an unenforceable agreement to agree, there are provisions in that LOI which are enforceable, such as the agreement that the parties would be responsible for their own expenses. There was also an exclusivity provision in there. So the Texas Business Organizations Code provides that LLC members are not liable unless they commit fraud for their own direct personal benefit. I've supplied the court with a couple of cases, the Trans-Pecos case and the Tech Logistics case in particular, where 100% owners of LLCs or a corporation, one's a corporation, I think, and one's an LLC, actually committed fraud, but the courts found that they weren't liable because they didn't do it for their own direct personal benefit. The courts hold that in cases where the direct personal benefit showing has been met, evidence showed that the funds derived from the corporation's allegedly fraudulent contact were pocketed by or diverted to the individual defendants. There's no evidence of anything like that happening here. I mean, I want to go back to the fact that there's no evidence of any kind of misrepresentation and no promise that Mr. Reardon made that without the intent to follow up on it. And so going back to the inferences that Mr. Hoopman talked about, you need more than inferences, you need genuine issues of material facts. And Mr. Reardon has also joined in the request for sanctions and costs that the Kyle financial appellees have requested, because not only was K. Griff prosecuting this case without authority because K. Griff had already sold the assets, including the causes of action, for more money to another company, but at the trial, which, by the way, they didn't, excuse me, they didn't allege anything differently than they had alleged the whole time. So the trial on the negligent misreps and the promissory estoppel were the same vague kind of allegations that K. Griff was being led on. So
let me interrupt you. Let me interrupt you real quick, Mr. Stone, on that claim for your cross point. Is there any evidence in the record that if we assume that KGI was the proper owner of these claims at all the relevant times, that KGI did not in fact approve of K. Griff asserting them?
There was an allegation that those claims had been assigned back, but it was our contention that the assignment was not effective and it was done late anyway. There was several months where it was done, where the case was prosecuted. To answer your question, though, that the lawyer for KGI knew that K. Griff continued prosecuting the claims. To go back a little bit more, when KGI found out about the claims, they intervened. Our case was put on, it was stayed, I believe, or abated, while KGI and K. Griff arbitrated their dispute against each other. And when they were done with that, K. Griff continued the case, KGI knew about it. So to completely and honestly answer your question, I think KGI knew about the prosecution. It's our contention that it's confusing. KGI is the entity that purchased K-Griff's assets.
Right.
So they did know about it. It's our contention that K-Griff's prosecution was still without authority and that the assignment was never valid.
When did KGI non-suit its intervention in relation to the arbitration award and the subsequent agreement? Do you know?
That was during trial, if I recall correctly. There was a time where we were still raising these issues, and I think that they did that at trial. I'm sorry, I didn't look at the record for those specifics, but I could find those answers.
Okay.
I would like to add one last thing, if I could, and that is that at trial, in their closing argument, K-Griff actually argued that my client, Mark Reardon, should have no responsibility. I mean, that's another reason why we're asking. There's an individual who's been dragged through trial, for 5 years, forced to go to a jury trial, defend himself, and at the closing argument, they don't even ask for any damages for my client. So with that, I'll turn it back. Thank you.
All right. Thank you, Mr. Stone. And we'll hear rebuttal now from Mr. Hoopman.
Okay, so Justice Jewell, you had asked me, well, what were the misstatements that were made? Some of them are that CRW is an established and viable company. It was not. Bill was financing that company from the beginning. And then the company ended up filing for bankruptcy because Bill cut off the funding. But my client was told that it was an established and viable company. My client was told that there was money for the deal. Money was not a problem. That was false. The only way they could get that was through Bill. That they said that the deal is done and will happen. And there's also the resetting at the request of Bill's lawyer. I forgot his name. I got the next some here, but Bill's lawyer had requested that resetting because he had a scheduling problem, not because they needed more time to do their due diligence and the other things under the agreement. And then the failure to disclose this really key person that had this large interest in the company, which is Bill. Okay. The thing about the inferences that I've spent a lot of time at the beginning is greatly re-emphasized by the two arguments that we just heard. Their arguments are arguments on the facts that are putting the facts in the light most favorable to them. That's the complete opposite of what you're supposed to do in this, an appeal at this stage of the game. And
Mr. Hoopman, let me just interrupt you for a second. So I have your appellate brief, your opening brief in front of me, okay, and the appendix, the emails that you had referred to earlier, they don't actually indicate any inferences that you've mentioned here. So are there more in the record that would support what you're saying? Because as you heard counsel say, that some of these emails weren't actually included in the summary judgment evidence at the trial court. Do you disagree with that?
No, I do not disagree with that. Let me elaborate on that. That was actually a point I was getting to. Okay, so you cannot cite to inferences because it's like smoke. Last night, I literally was driving home and there was a house on fire 2 blocks from my house, but I didn't see the fire, but I saw the smoke. And so I could testify that there was smoke. I saw it, but I couldn't testify that there was fire. And so you don't.
And you couldn't testify that it was a house.
Exactly. And so you can only cite to the record for facts, but reasonable inferences are fair game. And
but
so
inferences have to be somehow connected to the facts, correct?
Sure. Like if I saw a crow flying south, I saw it, but I can't infer from that the house was on fire. But I can testify that I saw a crow. So the Court of Appeals or the jury, depending on the procedural posture, they cannot take their inference that Tim saw a crow flying south and therefore his house was on fire because it's not reasonable. Okay, so but I can't cite to that. And as an appellant, I can cite to Dempsey and the Crow, but I can't take the inference that the house was on fire. Okay, so here you have all the things that were said and done and not done, because this is a, kind of a smelly sort of set of facts that we have here. And so you can actually cite to that, and then I can draw the inferences, which I can't cite to because they're inferences. Okay, now on the issue about what was attached to the summary judgment versus what was in the trial. Okay, here we have this crazy procedural can of worms here. So I got to deal with the record that was established at trial, because there's issues about what, should the verdict be set aside and et cetera. And then I got to deal with the evidence that was used in the summary judgment. Okay, so I attached all the email so y'all wouldn't have to read this massive record, right? So you go there and you see actually what the trial record shows. Okay, then you go back to the depositions and the affidavits that were attached to the summary judgment, which say the same thing as those emails, but not as in clear form. Ideally, you have the hard emails because it's right there. They said it, typed it, and it's there. So descriptively, if you go back to the summary judgment evidence, you will see the exact same thing that was going on.
Was there a motion to reconsider the summary judgment after the trial?
I do not believe so. Probably not. There were some motions filed. It's mind-boggling. There were like 14 summary judgments, but I do not believe that sort of motion was filed. No. But I think from a preservation point of view, that's actually not necessary. Okay, let me jump back to this. Maybe I'm overly emphasizing the inferences, but to me, that's really how you command this case from y'all's point of view of the write-up problem. Okay, so Mr. Knight was saying in his argument there that Kyle Financial, it's a lender. That's arguing the opposite inference. Okay, yeah, from his point of view, if he's pitching it to a jury, he's going to say that, and they could take that. But you got to look at it from the other perspective. He's not just a lender based on what went down here. He's a guy in the back that's throwing the money around. He's withholding money from these other investors unless they sell their interest to him. So he gets 50%. And the reason why not CRW, but the reason why he wanted this company is so that he could try to reinvigorate this company that he had been completely funding, which is CRW. So he's in the mix from the beginning. If you take the inferences that I keep talking about in the light most favorable to my client, and he's also telling people what to do. You got the letters from the lawyer. The lawyer's name is Jack Harden. That's the lawyer that was representing Bill, but Bill's also all involved with the CRW and also with Call Financial because it's all Bill. Okay, so he testified in the deposition that's attached to the summary judgment. This is on page 38 of my brief, that Bill Taylor has invested a large amount of money in CRW. And then there's it says here he testified that he was involved in the decision about what to say in the letter to basically change the story about why they were not going through with it, which was different than.
Just to clarify then, because I just want to get this straight before we run out of time. You're saying that Bill Taylor was the mastermind behind all of this. He was the bad actor. So then how would you prove fraud even by inference against any of the other defendants? Okay,
he's kind of like he's the lead guy. Okay, everybody knew what he was doing and they were doing what he told them to do because they would get their paycheck through CRW because Bill funded CRW and these people were getting paid real money. Okay, so they knew what was going on, and that's where the conspiracy kicks in because they're working with Bill what to say, what not to say, and so yeah, they're all in cahoots with him. But just because you got a lead criminal, and I'll use that word criminal loosely, I'm not saying Bill's actually a criminal, but using the analogy of criminality, if you got the lead guy over there making all the shots, that doesn't exonerate all of his actors that know exactly what's going on and then go out and do the overt act. Under conspiracy law, there's got to be an overt act. So they go out and do the overt act, furthering Bill's desires, which are to basically lie to Kathy so he can figure out what he's going to do to try to save the CRW that he's pumped all this money into before he got with Kathy, and it's not happening.
But what you're saying is not necessarily inference, but speculation, because from what I understand, you don't have any evidence of that back and forth between the defendants, right?
No, I think that we do. I think that isn't in the. I think there's in the perfect world, which I unfortunately never seem to live in. You put in all your evidence at the beginning. Okay, so here you would ideally want to have all of those emails and stuff in there, of course. Okay, but if you go look at the actual testimony and evidence that was put in the summary judgment, there's enough in there that it tells that same story, not with that same clarity, but it still tells the same story that I'm describing here. Now you can and should, in my, respectfully, you ought to look at the chain of emails. If you want to go actually read the ones in evidence, I wouldn't want to do it myself, but because I have, but I've tapped them all up. So they're exactly like what's in, because you got to read them in reverse and all this stuff. So they give you the really clear story about what's going on there. As far as what you were saying about speculation, that's always the battle, the philosophical, logical battle with inferences. Well, how far, when does an inference, when is it valid? When does it cease to be, a real inference and it's more speculative? That's always the challenge. And then that's of course the argument that to a jury. So, the court has to decide, is it a reasonable inference? If so, I get it. And their descriptions that they have given in their brief, especially Mr. Knight's brief, that's a jury argument brief. They're also he's disregard. In all respect to Stephen, I like the man, but his brief is arguing he's taking the wrong inferences. He's doing it the way you're not supposed to do it on appeal. And then he's complaining about what I'm saying in my brief, as if you can't even look at it, which that's just not how inference law works on appeal. So my time's way over. So
all right. Thank you, Mr. Hootman, for your argument. And thank you, Mr. Stone and Mr. Knight as well. The case of K-Griff Investigations, Inc. versus CRW is submitted. And we thank you for your arguments. You are excused.